Welcome back to The Price of Business. I'm your host, Kevin Price, talking to you about you and your business as usual. Glad to have on Lee Kaplan with Smyser, Kaplan of Veselka, the law firm, an extraordinary law firm practicing here in Houston. Well, I think you've got offices in other parts of the country, if I recall. But I want to always begin, because your practice is so unique, and you've got so many successes under your belt, and I just love the stories that you bring. Tell us again about the firm. Introduce the listener to the firm. And by the way, the best way to learn more about it is skv.com.
Well, thanks, Kevin. We actually have our only office in Houston, although we try cases around the country. We've had oil and gas cases in other parts of the country, patent cases in places such as the Northern District of California and the District of Washington, which is Seattle. We are defending one of the Deepwater Horizon defendants over in New Orleans. That's Captain Kaluza, and almost every charge has been dismissed in this case. They're down to a misdemeanor Clean Water Act violation, which is set to go to trial in mid-February. So we are a Houston-based law firm, but we have cases around the country and international.
Yeah, that's right. Talk a little bit about, you and I have been covering some stories over the last several weeks, including 3 major lawsuits that the Texas Supreme Court has been dealing with. Why don't you kind of give us a panoramic overview of those suits?
Sure. I've kind of canvassed some lawyers I know in the state for what they think are the most important things out of the Texas Supreme Court in the last 2 years. And they're really just 3 cases. One is called Ritchie versus Rupie, R-I-T-C-H-I-E, and that's a case that says there's no common law cause of action for oppression of a minority shareholder. So the thing that you take from that is if you're going to go into business in a small corporation, you need to have a contractual right as a minority shareholder, if you have some problem with the way the operation is run, to get relief, which means that you could, say, force a buyout. If you think say there are 3 of you, and you enter into a business, and the other 2 guys decide to pay themselves huge salaries, and they think, yeah, you're a shareholder, but we don't think you should get a salary, and we're running the business. Then you need a way contractually in the written documents to get some relief, to force them to buy you out or to do something. There's no common law right of a minority shareholder to get relief in that situation. That's the first thing, and that's been a very controversial and heavily criticized opinion, but that's the law in Texas. The second one, also from last year, is called Zachary Construction versus Port of Houston, and it's something that divides courts throughout the country. In contracts, people normally disclaim or frequently disclaim all consequential damages from a breach of contract. In other words, they'll say, all right, we're contracting, you're going to do something, we're going to pay you a certain amount of money, and if you claim we breached the contract in some way, then either side, you don't get consequential damages, you only get essentially the cost of the contract or a certain amount of money, depending on how the contract is written. Well, in this case, the Port of Houston had many changes to the contract, and was allowed to make changes, but it refused to pay extra money. And H.B. Zachary claimed, you've caused us a lot of extra damages, that it basically completed the project under protest. And the Texas Supreme Court ruled 5-4 that you cannot, in a contract, exclude damages that are caused by your own wrongful misconduct. And while that may seem like a fairly normal proposition, what it now means is that every breach of contract case, somebody will claim not only that you breached the contract, but that your conduct was, wrongful misconduct. And therefore, it means there will be probably more litigation to follow. And the final case is called Patel, P-A-T-E-L, versus Texas Department of Licensing, and this was the case in which some other interest group apparently got this department to issue rules for eyebrow threading, which required 750 hours of training that were probably pretty much irrelevant to the actual eyebrow threading. And the Texas Supreme Court said that is just obviously unreasonable, and they tossed it. The reason that's a pretty unusual case is, first of all, regulations are almost never tossed out by a court, because if an agency can show any kind of connection between what it's doing, its discretion is paramount. But this also opens up the ability of everybody to challenge every regulation and force the agency to really justify it, and puts the agency to a higher bar than they used to have to meet. So it's regarded by a lot of legal scholars as an important case. If you're in a regulated industry, you may want to take a look at the Patel case, which came up this year. Those are the three big cases.
Yeah, that is interesting. I think that probably of all of those, the one I find most interesting from a business perspective, because, Houston and Texas in particular, we love to boast here in Texas about how pro-business we are. I really think that the first one you mentioned, in terms of really no minority rights in dealing with executive decisions as far as salaries goes, is possibly the most chilling when you think of a venture capital perspective or that type of thing. What about your thoughts?
Well, what it really is it penalizes the people who went into a contract with somewhat rosy expectations or maybe naive expectations. You never think that your close friends or your cousins or your brother-in-law who you go into business with is going to do something that's unfair or wrong. But people have a way of falling out. So what this does is it rewards people who hire lawyers at the beginning and write up their deal much more carefully and thoroughly. The people who go into business essentially on a handshake or very limited documentation are going to be at a disadvantage. And that means if you're going to go into a business where you or somebody else is a minority shareholder, then you need to make sure that the corporations or the partnership's organizational documents, well, really we're talking a company, that the organizational documents spell out what happens when a minority shareholder feels that he or she is being treated unfairly. In the Rupee case, what happened is the Rupee shares were probably worth about $7 million, and the majority shareholders offered her only about $1 million, and she said, "I'm not accepting that," and she ultimately filed a lawsuit and got jury relief. The Court of Appeals had reversed it, but the Texas Supreme Court said no. The Court of Appeals had upheld that, but the Texas Supreme Court said, no, too bad. And there's no common law right of a minority shareholder to sue for shareholder oppression. And as I say, this is a case that's gotten a lot of criticism from commentators, but that is the law here. So don't go into a business until you've got clearly written documents what happens in this kind of event, which most people don't foresee when they start a business.
No. Obviously, which do you think has the biggest potential for impact?
I agree with you. It's Ritchie versus Rupee. I think that's by far the greatest impact of the three cases.
Well, we have got to wrap up the show with a brief conversation about the elections. Still unfinished business with the mayoral race. But what do you think? What do you think the situation looks like? I think, generally speaking, you would get the impression that Sylvester Turner would win. I get the impression, because this guy is one of the more positive candidates. He's not much for negative campaigning, but he sure has gotten negative in this campaign. I get the impression Turner is nervous.
Well, it's hard to tell. I watched the debate the other night. I guess I was one of probably 500 people in the whole city who watched it. And it's hard to say. I think the differences between the two are fairly clearly outlined, but nobody seems to know who's going to turn out for this election. I think that Sylvester Turner can count on a strong African-American vote. but I wonder if the Hispanics will turn out at all now that Adrian Garcia is not in the race. I think that the people on the west side who normally turn out will turn out, but that turnout may have been a lot greater the last time because they opposed HERO, the Human Equal Rights Ordinance, and that's not really an issue in the runoff. So, most people seem to think that Sylvester has a lead, but I don't know that that's true. I think the posters or the yard signs that Bill King puts up that says back to basic, fix the streets, fix the budget, catch the crooks, that's what people think they really want from the city. They don't think that the city is going to be able to do much about, say, inequality and things like that. They want these things fixed, and that may bring out some voters who might have otherwise been disenchanted. I think people more often vote their anger and their fears than they do their hopes.
That's what I think. I think that also explains the rise of Donald Trump. God bless him. God bless him.
Right. So I don't know.
Oh my goodness.
Don't know what's going to happen. If I had to bet, and I've apparently never won an election bet in about 10 years. Other than one time when I bet that Congress and the president would be from different parties. If I had to bet, I would say the odds are 3-2 that Turner wins, but I don't want to bet.
Yeah, I'm with you, and I think I give the edge to Turner just because of name ID, long-term name ID, and that type of thing. But I tell you, anyone who's familiar with our pension situation, and you see the endorsements Turner got, of course he's going to get union endorsements. They're trying to fight for that pension, which frankly is as bad as Chicago's and Detroit's pension situation. And I'm telling you, I'm not sure we want to keep punting that football.
Well, I agree with you, but it's in the very nature of politicians to try to avoid hard decisions.
Amen.
After all, we haven't seen too many Republicans to vote to cut or limit the growth of Medicare, Social Security. They'll rail against entitlements, but the Republicans haven't done much about that themselves, and that's like a third rail in Congress. So I think both sides can be accused, or both parties can be accused at various levels of not facing up to real issues. So
yeah, I could not agree with you more, my friend. That is the reality. The reality is that politicians. Guess what? With politicians, talk is cheap. Who would have thought? All right, Smyser, Kaplan, and Veselka. That's Lee Kaplan's law firm. That's skv.com. Thanks so much for being with us.
All right. Talk to you in a couple of weeks, I hope.
Yeah, I look forward to it. All right, when we come back tomorrow, we're going to have much more for you. Do want to remind you, best content here, it shows up over there at usdailyreview.com, and this is The Price of Business.